I'm Bill Montana, a real estate advisor and broker with Savills Studley. Today we're going to discuss the concept of loss factors in office space. Many tenants, when they're coming to New York City for the first time, are confounded by the concept of the loss factor. What is a loss factor? Well, the name loss factor is kind of a misnomer. It's really confuses an issue that's already somewhat confusing. A better term to use to understand this is the add-on factor. And the add-on factor is really the practice of taking a quantified area of space and adding to it as a way to increase profitability for owners of office buildings. So how did this practice begin to occur? Is it legal? And is it something that tenants can expect to be able to negotiate on? Well, it started out sometime in the 1960s when owners of office buildings that had multi-tenanted floors made the argument to the tenants that they should pay for their proportionate area of the floors that service them, areas like the hallways and bathrooms. And that seemed fair enough, and tenants went along with it. Next, landlords argued that all tenants should pay for all areas of the building which service them, areas including the downstairs main building lobby, the mechanical spaces, basements, and roof areas. That argument was a little harder to swallow, but tenants, especially smaller ones, eventually acquiesced, and it became common practice. Then, in markets where office space was scarce, they started applying an add-on factor so that if you had a piece of space, a floor that measured 10,000 square feet, they started simply calling it 12,000 rentable square feet, 14,000 rentable square feet, and so on. And today the practice has evolved or devolved, basically, depending on how you want to look at it, to the point where there's absolutely no connection whatsoever between an area of space that you can measure and what it's being called for purposes of renting. No connection whatsoever. But it's a practice that's become accepted, and virtually all sophisticated landlords in the city of New York employ some sort of add-on factor. Is it legal? Yes, because most leases, if you read them, will have words to the effect of, for all purposes under this lease, the specified premises shall be deemed to contain X number of rentable square feet. And tenants, if they sign that lease, are expected to be bound by it. Is it something that tenants can fight or negotiate down, the amount of the add-on factor? Unfortunately, no. It's really a factor that even tenants, large tenants with leverage, cannot expect to successfully be able to negotiate. So, what is a tenant to do when confronted with this kind of confusing practice? They should employ a team of experienced professional representatives. And that team should include a broker, an architect, and a financial analyst. And then what they can do is go out and engage the marketplace and evaluate each building and each space. See how much actual square footage it has, see how efficient it is for that tenant's particular specific use, and then look at what the annual aggregate costs are for that space. And by employing this methodology, tenants can then make informed decisions about which space is best and most cost-effective for their firm. Focusing on that annual aggregate rent number is the most productive way to do that, and to forget about focusing on the rent per square foot.